Welcome to today's program titled A Special Multi-Part Series, Guidance on Paid Family Leave Laws, Part 7, spotlighting Colorado, Oregon, and Washington State paid family medical leave developments. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them in the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down as it will not be reread and is required for CLE credit. Copies of the webinar recording and materials, along with the CLE attendance form, will be distributed to attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. At this time, I would like to pass it over to our first speaker for today's program, Meg Toth. Meg, please go ahead.
Thank you, Kate, and welcome everybody. Thank you so much for joining us today. We're so excited to be here for part 7 of our state and local paid family leave law series. Today, we're going to be spotlighting our favorite states in the Pacific Northwest, Colorado, Oregon, and Washington. And we have with us an amazing team of lawyers from SIFARF to help guide you through all of the complicated nuances and updates from these laws. First, we have Kira Johal, who's an associate in our Seattle office. We also have Emma Kazarian, who's also an associate in our Seattle office. And of course, Josh Seidman, as many of you know, I'm a partner in our New York office. So on the next slide, I am going to take us through our agenda and the topics that we're going to be covering today. We are going to kick it off with a brief nationwide overview of the status of the various paid family leave laws throughout the country. And then we're going to turn it over to Kira to talk about the Oregon paid family and medical leave law updates. And then Josh and I are going to cover the Colorado updates. And then we'll turn it over to Emma to cover Washington. And then we're going to close it out with a discussion of the paid family leave laws and outlook and what everybody can look forward to hearing about in 2023 and beyond. So with that, I'm going to kick it right over to Josh to talk about the nationwide overview of paid family leave laws.
Great. Thank you, Meg. Hi, everyone. Thank you for joining us, as Meg said, for part 7 of our ongoing webinar series. So happy to be here with you today. As you'll see on the next slide, the paid family leave, paid family medical leave landscape is continuing to expand. We are now staring down 14 total laws, 12 states plus Washington, D.C., as you can see on this slide, California, Colorado, Connecticut, Washington, D.C., Delaware, which is the newest of these laws that was enacted during the last 2022 legislative session, Massachusetts, Maryland, which also was enacted this past spring. Both of those don't go into effect for multiple years. We'll touch on that at the end of the presentation today. New Hampshire, New Jersey, New York, Oregon, Rhode Island, and Washington State, and not, of course, to leave out San Francisco, which has a paid parental leave law that tacks on top of the California State paid family leave program. A lot of moving pieces with these laws. As you'll hear about Colorado and Oregon, even though benefits are not yet available under those programs, there's still a lot of work to be done, employer obligations, substantive requirements to be aware of, even though both of those laws, again, are still not going online for almost a year in Oregon and over a year in Colorado in terms of when benefits become eligible. Washington State, which has been around for almost 2 years now, is still being amended and being updated, and that's the case with a number of paid family and paid family medical leave laws, making this a topic that is always in flux because we have new laws that are getting passed and existing laws that are getting amended. A couple of points about the nuances between these laws, and this does not mean the substantive nuances, of which there are many, eligibility, employer coverage, reasons for use, family members, the weeks of leave, and so forth and so on, certainly varies from one law to the next. But in terms of the general foundational setup of what these laws are and the type of laws that employers are facing, they're not all one size fits all. You have paid family leave laws, which are laws that provide time off for bonding with a new child, family member's serious health condition, perhaps military exigency, but not for a family member's own, or excuse me, for an employee's own serious health condition. In those states, in those programs, there is a separate but interrelated statutory disability insurance benefit law that provides coverage for that particular reason. I just go back one more slide for me. So in those particular jurisdictions, and those include California, New York, New Jersey, and Rhode Island. If you could just go back one slide, please. Those laws are paid family leave only. Now, the rest of the laws that are currently in place, those include Connecticut, Massachusetts, Washington State, Washington, D.C., and then the ones that are coming online, the two of which we'll be talking about today, Oregon, Colorado, those are all paid family medical leave programs. So big difference, again, and the medical leave is the key there because they include an employee's own serious health condition in addition to the bonding-related absences, the family member serious health condition, and so forth. Also, just to shout out one point, again, from the prior slide, would be New Hampshire. New Hampshire has a voluntary paid family leave program that is starting up actually this coming January. So it goes online January 1st, 2023, where employers that have 50 or more employees can purchase paid family medical leave insurance through this program. So that's a wrinkle in how these policies and programs are starting to look. Virginia also has a related wrinkle where earlier this year, the Virginia governor signed into law a paid family leave insurance as a class of insurance. So that's another wrinkle in what we're starting to see in terms of what paid family leave can look like from state to state and making the patchwork that much more difficult for employers to navigate. Finally, just a quick shout out before we move off of this slide. Hawaii does not have a paid family leave law, but it does have a statutory disability insurance law. And Puerto Rico has a temporary disability insurance and paid maternity leave program for birth and adoption. So as you'll see on the next slide, we previewed a little bit for you. There is, we do these from time to time, so this is a quick polling question. Nothing to throw folks off here, but no right or wrong answers. But we are curious, so we can help gauge the next several sections of our presentation today, in which of the locations that we're focusing in on, Oregon, Colorado, Washington State, does your company or organization have employees? And if you could, you should see sort of the pop-up on the right side of your WebEx screen there. You can just click. So is it A, Colorado only, B, Oregon only, C, Washington State only, D, at least 2 of those 3, or E, all 3? So if you could, and if you don't mind taking a look and clicking on which of those options is most applicable to your organization, and then we can, we'll see the results in just a second. They'll pop up for us. And then from there, we will take you into sort of the nuances between these laws. Again, understanding that with both Colorado and Oregon are going to be really starting and coming online in the coming weeks and months, and there are a number of employer obligations for folks to be aware of as those laws get moving. All right, we'll give it just another second or two here. All right, I see the polling has ended. Thank you for everyone who did submit a response. All right, so overwhelmingly, this is great for the folks who did respond. Again, thank you for responding. Folks either have operations in 2 of the 3 or all 3 of these jurisdictions, which is wonderful. Thank you again for everyone who participated. So we're now going to get things started with our substantive discussion of the Oregon Paid Family Medical Leave Program. I'm going to turn it over to Kira to walk us through all of the important developments in Oregon.
Thank you, Josh. Welcome, everyone. I will be discussing the Oregon Paid Family Leave developments. We have a lot to go over today. Next slide, please. So as a refresher, Oregon Paid Family Leave was enacted in 2019, and we are going to go over some relevant upcoming dates to keep in mind. All Oregon employers must allow employees to take paid leave benefits starting in September of next year. Employers are able to apply for an equivalent plan to the Oregon paid family medical leave that was open beginning September 6th of this year. Paid Leave Oregon has up to 30 days to issue a decision on an equivalent plan. Once approved, an equivalent plan becomes effective at the start of the next quarter. We'll discuss equivalent plans in more detail at a later point during this presentation. Also, beginning January 1 of next year, employee payroll contributions begin. On that same date, employers are required to post the model notice poster at each worksite and must provide the notice electronically or by mail to any remote worker. Beginning September 3rd of next year, employees begin receiving paid family and medical leave benefits. And for any assistant grants, those also start September 3rd, 2023. Next slide, please. So employee eligibility and coverage. For an individual to be eligible to receive paid family medical leave benefits, the individual must be an employee, and that is a pretty broad definition. Whether an employee works full-time, part-time, or a seasonal job, or for more than one employer, they may be eligible. What an employee does not include are independent contractors, employees of tribal governments, federal government employees, participants in a work-study program, or volunteers. For self-employed individuals, independent contractors, and employees of tribal governments that opt into the program are actually covered. Additionally, employees that are eligible for Oregon paid family medical leave also must earn at least $1,000 in wages during the base year. And what the base year means is the first 4 of the last 5 completed calendar quarters preceding the benefit year, or if not earned at least $1,000 in wages during the base year, the employee has at least earned $1,000 in wages during the alternate base year. And what that means is the last 4 completed calendar quarters preceding the benefit year. Next slide, please. Individuals must also contribute to the paid family leave fund during the base or alternative year to be qualified for the benefits. They also must experience a qualifying purpose for benefits such as family leave, medical leave, safe leave, or a combination of any of the 3. Individuals must also have current Oregon employment or self-employment for which they're requesting leave from work. They also must submit an application for benefits in accordance with all the requirements under the program. And individuals must not exceed their maximum paid leave and benefit amount in the active year. So for example, an individual may not exceed 12 weeks of paid leave per child for the purpose of caring for and bonding with the child during the first year after the birth or initial placement of the child, regardless if a new benefit year starts during that first year following the birth or initial placement. Individuals must also have no current disqualification from receiving benefits. Some disqualifications include individuals who are eligible to receive workers' compensation, or if the director of the employment department determines that the individual had previously willfully made a false statement or willfully failed to report a material fact in order to obtain benefits. Next slide, please. Employer eligibility and coverage. So covered employers are any person that employs 1 or more employees working anywhere in the state. So even that term is generally pretty broad, but employer does not include the federal government or a tribal government. For smaller employers that have fewer than 25 employees, they are not required to pay the 40% employer contribution into the fund. A smaller employer may elect to contribute the 40%, and if they do, they're eligible to receive assistant grants that begin September 3rd of 2023. So the employer may apply for 1 grant per employee up to a maximum of 10 grants per year. And these grants cover up to $3,000 towards the cost of hiring temporary workers to replace employees that are on leave, and up to $1,000 to reimburse for significant additional wage-related costs incurred while an employee is on leave. Next slide, please. So the amount of leave, in any given benefit year, an employee shall not receive paid family and medical leave insurance benefits that exceed an amount equal to 12 weeks of paid family medical leave per benefit year for leave taken for family leave, medical leave, or safe leave. 16 weeks maximum combined with paid family medical leave and unpaid leave under the Oregon Family Leave Act. As a reminder, the OFLA applies to employers with 25 or more employees working within Oregon. And employees must take leave under paid family medical leave and the Oregon Family Leave Act at the same time, only if the leave purpose is the same. Otherwise, employees do not have to take paid leave at the same time as the Oregon Family Leave Act. Additionally, employees can also receive 2 weeks on top of that of leave for limitations related to pregnancy, childbirth, or related medical conditions, including lactation, but no leave can exceed 18 weeks. Next slide, please. So covered reasons for use under Oregon Paid Family Leave. So Oregon Paid Leave provides eligible employees with leave for their own or a family member's serious health condition. Oregon law recently expanded what is considered a serious health condition to include an illness, injury, impairment, or physical or mental condition that requires constant or continuing care or involves a period of incapacity. So incapacity is the inability to perform at least one essential job function or to attend school or perform regular daily activities for more than 3 consecutive calendar days. A period of incapacity includes any subsequent required treatment or recovery period relating to the same condition. The incapacity must involve either 2 or more treatments by a healthcare provider or 1 treatment plus a regimen of continuing care. A serious health condition also involves multiple treatments for restorative surgery or for conditions such as chemotherapy or dialysis, or any period of absence for donations of a body part, organ, or tissue. For family leave, that includes care for and bond with a child during the first year after the child's birth or placement, or to care for a family member with a serious health condition. What family leave does not include is to care for a child of the employee who is suffering from an illness, injury, or condition that is not a serious health condition, but that requires home care, bereavement leave under the Oregon Family Leave Act, or military leave under the Oregon Military Family Leave Act. Next slide, please. So additional covered reasons for use. Oregon paid leave law also provides safe leave related to domestic violence, harassment, sexual assault, and stalking. Recently adopted rules further define safe leave for sexual assault and stalking. So sexual assault is defined as any sexual offense or the threat of a sexual offense. And then stalking is defined as the crime of stalking or the threat of the crime of stalking, as well as a situation that results in a victim obtaining a court's stalking protective order or even a temporary protective order against the stalking. Next slide, please. Employee written notice requirements. So employers may require employees to give notice when they will be taking leave. An employer may require written notice to include the employee's full name, the type of leave they will be taking, an explanation of the need for leave, and the anticipated time and duration of the leave. So written notice includes handwritten or typed notice, as well as electronic communication such as text messages and email that is consistent with the employer's known policies. Whether leave is to be continuous or is to be taken intermittently, notice only has to be given one time, but the employee must advise the employer as soon as practicable if dates of scheduled leave change, are extended, or were initially unknown. Additionally, an employee is not required to expressly mention the paid family and medical leave insurance program when giving the employer written or oral notice. So the timeline for giving notice may differ depending on whether the leave is for planned or for an unexpected event. If employees take paid leave for a planned reason, such as an upcoming surgery or adopting a baby, they need to let the employer know 30 days before taking leave. In an emergency, employees must tell their employees must tell their employer within 24 hours and give written notice within 3 days of starting that leave. And for unexpected events, that can also include, but is also not limited to, unexpected serious health condition of the employee or a family member who has experienced an unexpected serious health condition, a premature birth, unexpected adoption, or unexpected foster placement by or with the employee, as well as safe leave. If an employee does not provide the correct notice to the employer, the employment department may reduce the employee's first weekly benefit amount by up to 25%. So the Oregon Employment Department will notify the employer when a claimant, so the employee, has applied for paid family leave, medical leave, or safe leave benefits. And then the employer can respond to the notice from the department within 10 calendar days from the date of the department's notice to report if an employee has failed to provide the required notice and whether an employee's first weekly benefit amount will be reduced. Next slide, please. So funding mechanism. So employers must begin withholding employee contributions for Oregon paid family medical leave starting January 1 of next year. Employee contributions must be held in trust until paid to the employment department, and paid leave contributions are made to the department through the combined payroll reporting process. The contribution rate for 2023 has been set and is 1% of each employee's wages up to a maximum of $132,900 for the year. Employees pay 60% of the contribution rate and the employers pay 40% of the contribution rate. So for example, if an employee made $1,000 in wages, the employee would pay $6 and the employer would pay $4 for that paycheck. And of course, employers with fewer than 25 employees are not required to pay the employer portion of contribution, but can elect to do so. The contribution rate is set annually and will not be more than 1% of each employee's gross wages. The maximum amount of wages is also adjusted annually based on inflation. So the department will announce the contribution rate and maximum wage amount by November 15th of each year, and the new rate and maximum wage amount will take effect January 1 of the following year. Additionally, the employer is not responsible for paying employee wages while an employee is out on leave. Instead, the Paid Leave Oregon program would pay eligible employees an amount on their wages during that leave. Next slide, please. Okay, so a very important deadline coming up. By January 1 of next year, employers are required to post the model notice poster at each worksite, and they must provide it electronically or by mail to any remote workers. So the Paid Leave Oregon program has provided a model notice for employers to use on their website, and the notice looks like the image on the right of this slide that's provided here. In the notice, it must include information on the right of employees to claim and receive paid leave benefits, how to file a claim to receive benefits, the requirements for employees to notify an employer for foreseeable and non-foreseeable leave, the process to appeal benefit decisions, job protection and continuation of health benefits during paid leave, prohibition of discrimination and retaliation related to the use of paid leave, the confidentiality of health information that's provided, and how to file a civil action or file a complaint for a violation of rights under the Oregon Paid Family Leave law. Next slide, please. So circling back to equivalent plans. So Oregon employers can provide paid family medical leave and safe leave benefits through an equivalent plan instead of using the state paid leave Oregon program. Employers must apply to the director of the employment department for approval, and the department began accepting equivalent plan applications in September of this year, and the application fee was $250. Employers must provide benefits that are equal or greater than those provided by the state paid family leave program. So an approved equivalent plan is required to cover all employees under the plan within 30 calendar days of their start date if all employees were previously covered under the state plan, and on the date of hire if all employees were previously covered by an Oregon approved equivalent plan. So this is pretty important because employers must keep a lookout and also work with the Oregon Employment Department to determine whether an employee was previously covered under a state plan on the date of hire, or if they were previously covered by another employer's equivalent plan on the date of hire. An approved equivalent plan also must allow leave for family, medical, and safe leave. It must provide up to 12 weeks of paid leave per year, plus additional 2 weeks for pregnancy-related medical leave. It also must allow employees to take a paid leave 1 day at a time or for a longer period of time, and have no additional conditions or restrictions for employee use of paid leave similar to the state program. Employers must also reapply for approval of their equivalent plan every year for 3 years, or if the plan substantively changes, and if that is what occurs, a substantive change, then the 3-year reapproval starts all over again. Next slide, please. Okay, so some deadlines for equivalent plans for 2023. So to be exempt from the required quarterly contribution payments, employers must submit their equivalent plan application by November 30th of this year to be exempt from paying contributions beginning the first quarter that starts January 1 of next year, or by February 28th, 2023 to be exempt from paying contributions beginning the second quarter that starts April 1 of next year, or by May 31st, 2023 to be exempt from paying contributions beginning with the third quarter that starts July 1 of next year. If an equivalent plan approval is canceled for any reason, whether by the employer or the director of the department, before September 3rd of 2023, the employer must collect and pay contributions for all unpaid periods since January 1 of 2023, and on top of that is subject to penalties and interest. If the approval was canceled, the employer cannot withhold additional funds from an employee's wages to pay for additional contributions. So far, that covers our most recent Oregon paid family leave updates, and I'll turn it over to Meg.
Great. Thank you so much, Kira. Moving right along to Colorado. So Colorado's law is not, in fact, new. It passed in November of 2020 as a ballot initiative. But it's important because premium withholdings are about to begin on January 1st of 2023, with also a posting and notice obligation required on January 1st of 2023 as well. Although it's important to understand the posting and notice requirement, it does appear to be an express requirement. But that's because there is a toolkit on their website that calls it the required 2023 family program notice poster. It doesn't necessarily expressly contain that in the law. So it's important to be aware of this requirement, which may sort of fly behind the radar a bit. Another important date to be aware of is the first reporting and remitting deadline, which is April 30th of 2023. And then the paid family leave benefits will be available for employees beginning January 1st of 2024. It's also important to understand we've received an update regarding private plan applications, and I wanted to flag this here. We'll be talking about that in a little bit. But an important deadline there is that employers must apply to the FAMLI family division for a private plan exemption approval by October 31st of 2023. So if you're planning on submitting an application for a private plan, that's an important deadline to also be aware of as well. Alrighty, so moving on to the next slide, which are the eligibility and coverage requirements. As a reminder, employees who are eligible for paid family and medical leave include any individuals who are performing labor or services for the benefit of another who earn at least $2,500 in wages subject to premiums under the law during the person's base period or alternative base period, or is self-employed and elects coverage. The only thing that's important to understand here by way of update is that an individual claimant can meet this threshold by earning wages subject to premiums from any combination of employers, which could get kind of complicated for employees that are working for multiple employers. And that total amount does not have to be from their current employer to meet the threshold. So that's just an important update to be aware of. In terms of employer coverage, any person engaged in commerce or an industry or activity affecting commerce that employs at least one person for each working day during each of 20 or more calendar work weeks in the current or immediately preceding calendar year, or paid wages of $1,500 or more during any calendar quarter in the preceding calendar year is covered. So this is a lot of language or a lot of words, but it is a very broad employer coverage. So if you have employees in Colorado, you're likely covered. Alrighty, so in terms of the amount of leave on the next slide, so this isn't also new, but we do have some updates regarding the amount of leave. As a reminder, the Colorado law provides 12 weeks in the aggregate for paid family and medical leave, in addition to 4 weeks for serious health conditions related to pregnancy complications or childbirth complications. A recent update includes additional details regarding what it means in terms of the application year, and this is basically a rolling 12-month period is when this amount of leave benefit is calculated. So an employee can start, once they start using the medical leave, it sort of starts calculating from the first date that they use the paid family or medical leave, and then that time starts to drop off as the 12-month period rolls by, similar to FMLA. There also has been an update regarding guidance on intermittent leave, but we'll be talking about that a little bit more later in the presentation. But for now, it's important to understand that approved leave may be taken continuously, intermittently, or at a reduced scheduled leave. Alrighty, on the next slide, the reasons for leave. So Colorado is one of the laws that includes family leave and self-medical related reasons for leave. This includes for the birth, adoption, or placement of a new child, for an employee who has a serious health condition, for an employee that's caring for a family member with a serious health condition, and then also for leave related to qualifying exigencies, and also for safe leave. So one of an important update, an important nuance to cover related to the date of the qualifying condition. For example, when an employee has a serious health condition, well, paid family and medical leave insurance benefits aren't necessarily available for use until after January 1st of 2024. If the employee had a qualifying condition that arose before that date, they could potentially qualify for paid family and medical leave after January 1st, 2024, should the need for leave still be available. For example, if somebody had a serious health condition that arose in 2023, but they still needed time off after January 1st of 2024 for that serious health condition, they could potentially, or they really are entitled to take the time after January 1st of 2024, even though that serious health condition arose in 2023. Another thing related to these reasons for use that's important to note is related to bonding leave. So for the birth, adoption, or placement, if a person has received benefits for bonding with a child under the paid family medical leave law to care for a foster child, and then that person later adopts the child, they're not entitled to receive benefits again for both the foster period and the adoption period if they had exhausted their benefits related to fostering the same child that they're going to be adopting. Okay, so those are the important notes and updates regarding reasons for use. Moving on to the next slide related to covered family members. So for purposes, as a reminder, for purposes of the Colorado law, family member includes children, which means a child regardless of age. It can be a biological, adopted, or foster child, a stepchild, or legal ward, a child of a domestic partner, a child who the covered individual stands in loco parentis, or a person whom the covered individual stood in loco parentis when the person was a minor. So the definition of child is pretty broad. It also covers parents with a similarly broad definition of parent, including the spouse or domestic partner's parent. So that's important to understand. It also includes spouse or domestic partner, and the definition of that is relatively straightforward. It's a person to whom the covered individual is legally married under the laws of a state, or a domestic partner of a covered individual as defined under Colorado law. It also covers grandparents, grandchildren, as well as siblings. And then it also includes, and this is a little bit unique, any other individual with whom the covered individual has a significant personal bond or that is or is like a family relationship regardless of the biological or legal relationship. And what's new here is that the sort of understanding of what it means to have a significant personal bond has been clarified through guidance, and it is basically analyzed under the totality of the circumstances. So to determine whether an individual is a family member, an employer can look at various issues surrounding the relationship, including but not limited to things like shared financial responsibility, including shared leases, common ownership of real estate, joint liability for bills, or beneficiary designations. And there are a whole bunch of other characteristics or qualifications that you can look at, such as the cohabitation and duration of people living together and geographic proximity. Alrighty, and then moving on to the last slide I'm going to cover before I turn it over to Josh. I'm not going to talk too much about the calculation of weekly benefits because it's a lot of math, and I think the slides are going to be available for everybody to read. But it is really important to understand how the benefits are calculated, and the updates and current guidance that was recently released impacts a number of topics related to this issue, including how to handle employees that work multiple jobs, like I mentioned before, employees whose leave duration is less than a week, absences of less than 8 hours, and many other topics that are important to pay attention to. So I will leave you with that on the calculation of weekly benefits and turn it over to Josh to talk about the rest of the topics.
Josh, you're on mute.
Thanks, Mike. So big important topic, the funding mechanism, given the upcoming January 1st, 2023 deadline for employers to begin their premium amount collections. So for the next 2 years, beginning in 2023, the amount of the premium will be equal to 0.9% of wages per employee. After that, the director of the Colorado Division of Family and Medical Leave Insurance will set the premium based on a percentage of employee wages. Now, going forward, right, starting in 2023, it really depends on if your company has 10 or more employees or fewer than 10 employees. Now, if you have 10 or more employees, the employer may deduct up to 50% of the required premium from the employee's wages and then has an obligation to remit the full 100% of the premium to the state fund. Now that again is, so 50% would effectively come from the worker and the other 50% from the company. Now for smaller employers, those that are under the 10 employee threshold, they still can collect up to the 50% of the premium from their employees, but only have an obligation to remit 50% of the premium to the fund. Employers have the obligation, notice I use the word may, right? They have the option, excuse me, to choose to cover their employees' portion as an added benefit, something as a differentiator to help retain talent and the like. So an option like that is available for certain employers if they so choose. In addition, there are several resources that the state has released that employers can use to notify their employees of this upcoming payroll deductions before January 1st. There's a poster that is available as well as a paycheck stuffer. So be on the lookout for both of those. And finally, the amount of wages that's subject to premiums. I saw this question come in from one of our attendees about the upper limit in terms of the amount of wages that would be subject to the premiums, and it cuts off for Colorado. I saw that for Oregon. It cuts off for Colorado at the Federal Social Security Administration annual amount, and I believe that's the case in Oregon as well. Next slide, please. Okay, great. So very related topic, reporting and remitting. Those obligations, again, will be starting up in 2023 with the first reporting and remitting deadline, as Meg mentioned, coming up on April 30th of next year. Now, very importantly, the Family Division, the Colorado FAMLI Division, has indicated that while there is still ongoing rulemaking around this particular topic of private plans, any employer, whether they are going to be pursuing a private plan or not for Colorado paid family medical leave purposes, will be under an obligation to collect and remit premiums in 2023. Now, if an employer does go through the process of getting their private plan approved and they submit their private plan by October 31st of next year, so they have over a year to do this, then the employer would be eligible for a reimbursement from the state. So administratively, it sounds a little bit of a clunky process, but that is the guidance that the state has issued. So again, very important that all employers, whether you're pursuing a private plan or not in the coming months, will be under the obligation to collect premiums starting in 2023. And again, the wage reports will also be due at the same time as the pay remitting. Those reports should be very similar to how companies in Oregon submit their unemployment insurance today. Next slide, please. Okay, so very quickly, Meg already covered this in the introduction. Here's a link to the model notice in terms of employers' notice and posting requirements. Best practices is to assume that these obligations do begin as of January 1st of 2023. Next slide, please. So is there job protection under the Colorado law? The answer there is yes, there is. The employee, only if though, right, the employee has been employed for at least 180 days prior to their leave. So if the employee has been employed for that duration of time or longer, then the employee will be entitled to, upon returning from their leave, restoration to the position that they held before they began the leave or to an equivalent position with equivalent benefits, pay, and other terms and conditions of employment. The law also does prohibit things like retaliation, discrimination, and interference. Next slide, please. So Big important topic. Again, private plans, I mentioned this a minute ago, but just to really drill down on it, there is still ongoing rulemaking with respect to private plans. There will be opportunities to apply through the division in the coming months. But until then, and employers are under the obligation to follow the premium pay requirements that I discussed in the previous slide. And if you submit everything timely and get your private plan approved by the state, then there will be a reimbursement that is sent to the company for their 2023 premiums that were remitted to the state. Next slide, please. So as Meg and I have covered on the last several slides, a lot of new content in Colorado as we really ramp up this program before it goes live with benefits and beginning in 2024. Still rulemaking going on, but a lot of important information that has been touched upon through the rulemaking that has already been finalized. Among the topics we've already discussed, you can see on this slide, there have been impacts on terms of documentation, the claim filing process, intermittent leave, record keeping, and still forthcoming, very important topic for a lot of companies, coordination of benefits. So documentation touches upon different relevant types of documentation for all the various covered absences that Meg went over. There's also a 6-month recertification requirement on employees who are out on intermittent or reduced schedule leave, as well as guidance about the permissibility of a fitness for duty requirement. Lots of good information about the claim filing process in terms of the application submission method, the timing that the division says they're going to turn around a properly filed complaint. They say it'll be within 2 weeks, so we'll see if they can keep up with that goal. It seems a little ambitious, but we'll see if they can make that happen once the benefits go live in 2024. Intermittent leave, again, lots of good content there with respect to documentation, with respect to employee notice, and the fact that in the latter point, that notice does need to be provided to the division with respect to each individual absence if an employee is approved for intermittent leave. And then finally, record keeping. There is new guidance about maintaining medical certifications, recertifications, and the like confidentially in medical records separate from usual personnel files. So with that, we're going to pass it over to Emma to take us through the updates in Washington State.
Hi, good afternoon, everyone. Thank you for being here and welcome. I'm Emma Kazarian. I'm an associate here in the Seattle office, and I'll be taking you through the Washington paid family medical leave and the updates. Next slide, please. So just a quick overview. As you've seen today, like with Oregon and Colorado, Washington PFML, that's what we call it, it's not just sort of a statutory framework that tells employers, these are your mandates, this is what you need to provide to employees. It's actually a state-administered paid family and medical leave program. So it's not unlike unemployment insurance, and it's administered in much the same way. And in fact, in Washington, the Employment Security Department, which is the state agency that administers unemployment insurance, also administers PFML. And in terms of how it's funded, we have premiums. The premiums are collected from employee wage deductions, and for employers with more than 50 employees, they also pay into this pot that's held by the state. And then when then the funds in the pot are disseminated to employees that make an application for benefits to the state. And we're going to be going through this really fast and furious today, but what I'll say is there's so much information, just like you saw with Oregon and with Colorado, a really robust statutory framework that tells you exactly what the definition of employee is, what the definition of employer is. In Washington, it's very expansive. But I think that for an employer that's participating in the state administered plan, really there are a couple of duties that are most important to sort of be on top of and be aware of. And those are first, that employers have a duty to notify employees about the benefit. So just like in Colorado, just like in Oregon, there is a workplace poster. ESD also publishes, and that is mandatory. But also ESD publishes what Josh called, I think, a paid stub stuffer, so an optional insert that you can put in. But also employers have a duty when they become aware that an employee is taking leave for what might be a qualifying reason, to let them know that they may be eligible for benefits under the state program. The other thing that employers need to be on top of is calculating, collecting, and remitting premiums to the state. And then along with that, there are quarterly reporting requirements. And so that entails, reporting on employee wages, the hours worked, and then the premiums that were collected. And again, just like in Oregon and Colorado, nothing new under the sun, I suppose. There is an option for employers to essentially seek to be exempt from the voluntary plan, or sorry, from the state administered plan by implementing their own voluntary plan. But that is something that you'd have to get advance approval from the state in order to be able to do that. So it's not enough to just say, hey, we have this great plan that's actually more generous than what the state offers. And so, we're just going to kind of not do the collecting and remitting the premiums, and we're just going to do our plan. You have to make an application for benefits. It has to be approved by the state. And then the voluntary plan, as I said, does have to be at least as generous as what the state provides. Next slide, please. So this is with regard to the amount of leave. In Washington, it's, oh, sorry about those gray boxes, if folks are seeing that. It's kind of like a little bit of a three-tiered approach. So sort of the most simple is if an employee is experiencing one discrete qualifying event in a year, whether it's under the umbrella of a medical leave or a family leave, they get up to 12 weeks. And so an example of that might be, the employee requires spinal surgery, and that's their only event in the year, and they take family medical leave for that. They get up to 12 weeks, or they need to take, time off to care for a family member who's going through chemotherapy or something like that. They get 12 weeks if it's just one event, one discrete event. Now, if the employee has two events in a kind of benefit year that, one for a medical event and then a family leave event, that a qualifying family leave event, they can get up to 16 weeks. And so sometimes this looks like two discrete events. So kind of in the example that I gave previously, the two discrete examples, if both of those things happened to an employee in a single benefit year, they would be eligible to take up to 16 weeks. But really the more classic example that we see is employees who are pregnant or giving birth to a baby. And so that that kind of also triggers the 16 weeks because they are eligible to take medical leave for themselves if they're the parent that's giving birth for the postnatal period. And then after that, they're eligible to take medical leave for, bonding with the baby. And so in that instance, they get 16 weeks. And kind of taking that example and drawing on it, if during that benefit year, the employee also experiences a pregnancy-related complication or something like that that results in incapacity, so something other than sort of the act of delivering a baby. So an example might be like if the employee is put on bed rest or suffers from postpartum depression, the employee can actually be eligible for an additional 2 weeks on top of the 16. So for a grand total of 18 weeks. Next slide, please. And then I previewed this a little bit, but as the name implies, and as you've seen in the other two states that we've been talking about here today, there's really sort of two categories of leaves. There's the medical leave, that's the employee's own serious health condition. New this year, we have clarifying guidance that says leave taken during the 6 weeks after delivery is considered, is presumptively medical leave. So after delivery of a baby, they call it the postnatal period. Those 6 weeks are considered medical. And then there's also family leave, which is leave taken to care for a family member with a serious health condition. Also leave taken to bond with a baby. And new this year, we also have bereavement leave, and that only applies in very specific circumstances, which I'll summarize at the end. It's related to leave for the death of a child. Next slide, please. So this is something that is new and kind of juicy, so I wanted to talk about it. When Washington paid family medical leave first went into effect, so when employers were first sort of had the mandate to start collecting premiums, which was in 2019, it was 0.4% was the premium. And there wasn't really a mechanism for like that being adjusted. But what happened was earlier this year, state agency officials from the Employment Security Department, which administers this program, they reported to the legislature that they were having huge solvency issues with the paid medical leave program. And, you know, it's hard to kind of pin it on one thing. Like the first year that employees were eligible to take benefits was COVID. It was 2020. And so, you know, that probably put a lot of unexpected, unanticipated strain on this new program that we were rolling out. But in any event, long story short, what ended up happening was the laws changed. So now premiums for 2022 are up to 0.6% of gross wages. So there's been that increase. And now in the statute, there's also a little bit of a framework for how to calculate. Right now, it looks like the 0.6% is going to be the upper limit, but there is also, and it's kind of recalculated annually based on the ephemeral account balance. So the commissioner recalculates it. For now, 0.6% is the cap, but there is also the ability for them to implement what's called a solvency surcharge. So I just wanted to highlight this because this is new and it was kind of unexpected and I think a pretty big deal. So next slide, please. This is my last slide here for you today. I know that was fast and furious, so please do feel welcome to reach out with any questions we weren't able to get to. But this is just a summary of, other than the premium changes, the changes that went into effect this year over the summer. So bereavement leave for death of a child, this has been added as an eligible reason for taking family leave. And statutory bereavement leave is only available for parents in very limited circumstances. So if, you know, it's a baby that dies and the you know, parent would have been eligible to take bonding leave for that child, or would have qualified for medical leave related to the birth of that child. So as it reads, as the language of the statute and the kind of corresponding rule reads, that should cover miscarriage, but we haven't seen any test cases yet. This is very new. And then, as I previewed earlier, the postnatal leave, so the first 6 weeks following delivery of a baby, are now presumed to be medical leave. The waiting period clarification, this is something that for anybody that's been working with PFML, not really surprising, but there was a clarification that the waiting period doesn't reduce the maximum duration of the employee's available leave. And then finally, there was a collective bargaining exemption, or there is, but it'll expire in December, on December 31, 2023. So as I said, that was really fast and furious. Please do feel welcome to reach out with any questions, and we would be happy to help.
All right, Emma, thank you so much. As you'll see on the next slide, just a very quick overview of 2023 paid family leave outlook. We've already discussed Oregon and Colorado, reminders about the upcoming important dates. There are obviously others that we touch upon, but these are when payroll deductions begin and then benefits begin. Maryland, the payroll deductions will be starting up October of next year to fund benefits that go live in the beginning of 2025. And then Delaware, payroll deductions and benefits will follow starting in 2025 and then 2026 respectively. Next locations likely to adopt, you see the list of potential states here. We already mentioned that last legislative cycle, there was big news with both Maryland and Delaware. We're expecting another sort of wave of 1, 2, maybe 3 states of this list, maybe a dark horse that isn't even listed here, to come online or to at least get enacted sometime during the 2023 state legislative cycle. So keep that in mind. Also keep federal paid family medical leave in the back of your minds. There was a lot of traction on this topic in 2021 with the Build Back Better Act. It fizzled as the act got watered down and reduced. But federal paid leave, depending on what happens with the upcoming election in a few weeks, we could see as a bipartisan issue that there might be a middle ground. So pay attention to the possibility of federal paid family medical leave. I'm going to turn it over to Meg now to very quickly wrap this up and give folks, the CLE code. I'll actually take care of that. So the CLE code for everyone, thank you for attending, is SS as in Seyfarth Shaw 6763. So again, SS 6763. And Meg, the floor is yours.
Perfect. Thanks so much. So in the last 30 seconds or so here, as you can tell by our presentation, these laws are incredibly complicated, and the more that come online, the larger the patchwork grows. So if you're looking for some help, as many of us have mentioned, feel free to reach out. We also have a ton of great resources that our fabulous team of attorneys have been working on tirelessly. This includes a paid family leave survey that breaks down the specific requirements of each of the existing state and local paid family and paid family medical leave laws. If you want information on that, you can reach out to our email listed on the slide. We also have a mailing list where we send out updates and blog posts, so you can sign up for that. We're listed here on the link. And then 2 more resources on the next slide. We have a webinar series that you obviously are aware of because you're here today. So here, those are recorded. So we wanted to just sort of give a recap of what we've covered so far. And also put in a shameless plug for our Take It or Leave It podcast, which Josh and I are the hosts of. We launched this podcast last year, exclusively talking about leave of absence management and accommodation issues. We have covered a number of paid family leave laws already and parental leave laws, and we have a lot of good content in the works as well, so check that out. And that is all we have for today. So thank you again for joining us. We hope you thought this was helpful. And if you have questions or need information, please feel free to reach out. Thanks so much.
Thank you.